Even though the Caribbean firm does a lot of great work for our union and many others for our members. He joined the firm in 1986 and has been representing members of the Machinists Union for over 25 years. He serves on the board of directors of the Wisconsin Academy of Trial Lawyers. His practice is limited to representing individuals who have been injured during the course of their employment or as a result of the conduct of others, including claims involving medical negligence, product liability, premises liability, and motor vehicle negligence. He has tried cases before the state and federal courts throughout the state of Wisconsin. Steve has developed a reputation as a tireless advocate for the rights of workers and is a frequent lecturer on topics of civic litigation and workers' compensation. Welcome, Attorney Steve Kluender.
So, who was present when I spoke to the delegates at the September conference? Okay, so not all. All right, for those of you that were present, you're going to have to live through a little bit of a endorsement for my firm. Our law firm has been representing labor unions and their members since 1912. We are the oldest and largest union-side labor firm in the country. Our firm grew out of and nurtured the labor movement across the entire United States, and we continue to do that today. But in addition to our practice representing labor unions, we have one of the largest litigation practices in the state of Wisconsin. That section of our firm specializes in workers' compensation, personal injury claims, Social Security, disability. And rather than go into a lot of detail, I would really ask you to take a look at our website to see the type of results that we've obtained on behalf of union members and their friends and families. As Alex suggested, we represent only individuals in labor unions. We don't represent corporations, we don't represent business, we don't represent insurance companies, and we don't represent employers. Now, another service that we provide to members of the Machinists, and perhaps one of the greatest benefit, is we provide free legal consultation to union members and their families. Our full-time office is located in Milwaukee. That office has a toll-free number that you can use to call, but we also travel to locations throughout the state on a weekly basis to provide personal consultations. We travel to Fond du Lac, Sheboygan, Needham, Nashua, Horicon. Within the next 2.5 weeks, I'm going to be up in Ladysmith in Rusk County, if any of you guys know where that is. I'll be in Marshfield, and I will be in La Crosse. So we have a very strong statewide practice. Now, at the state conference in Wausau September, I explained the role of the Workers' Compensation Advisory Council as well as some potentially devastating changes that were being proposed to the workers' compensation statutes. And since that presentation, there has been a lot of activity on the legislative front. And I intend to use my time today to give you some good news and to give you some bad news. But first, for those of you who weren't in the audience during my earlier presentation, I'm going to start with a little bit of background information. Now, Wisconsin was a pioneer when it came to protecting employees who were injured during the course of their employment. In 1911, Wisconsin became the first state in the nation to enact a comprehensive workers' compensation law. Prior to enactment of that law, if a worker was injured at work, he had to sue his employer for damages, even if the injury was clearly the employer's fault. And you can imagine how difficult it was for a worker who was injured and out of work to be forced to sue his employer to get some form of compensation for his work-related injury. Now, the Workers' Compensation Act of 1911 created a no-fault system designed to provide injured workers with prompt treatment, benefits for lost wages, and an incentive to return to work after they healed from the effect of their work-related injuries. And for over a century, this system has provided employers insurers, and injured workers a stable environment with minimal litigation. And every citizen of this state, and I just made this pitch to a number of legislators when I was promoting a new Workers' Compensation Act. Every citizen of this state can be proud of this state's strong workers' compensation system. It's fair to all affected parties, and it is admired throughout the country for its stability and efficiency. Research has proven that Wisconsin's injured workers heal faster. They return to the workforce on average 3 weeks faster than injured workers in other states. Wisconsin's system has lower costs. According to a 16-state study of work-related injury claims by the nonpartisan Workers' Compensation Research Group, Wisconsin's injured workers are able to navigate the system effectively, resulting in less litigation, which is beneficial for both workers and employers. Wisconsin's workers' compensation insurance premiums are stable and low. They've risen at a pace less than inflation over the last 6 years. And Wisconsin's workers' compensation system is completely funded by those workers' compensation insurance premiums and doesn't take in 1 penny of taxpayer dollars. Now, the stability of Wisconsin's workers' compensation system is in large part the product of a long-standing and proven process which was established for enacting changes to the Workers' Compensation Act. Almost 50 years ago, the legislature, with the specific purpose of insulating the workers' compensation system from partisan politics and to ensure proper representation of all parties affected by the workers' compensation system, created the Workers' Compensation Advisory Council. Now, by statute, the Advisory Council is comprised of 10 representatives, 5 from labor, 5 from management. Was Stephanie Bloomendale here today? Stephanie, Secretary-Treasurer of the AFL-CIO, is the chairwoman of our labor caucus for the Wisconsin Workers' Compensation Advisory Council. I can speak to you today because I am one of the 2 lawyers in the state that advise the labor council, or labor caucus with the Workers' Comp Advisory Council. But in addition to labor and management, there are also 3 representatives of the insurance industry and 4 representatives of the healthcare industry who participate on the advisory council as non-voting members. The composition of the council fairly represents the interests of all stakeholders in the workers' compensation system. The task of the council is to advise the legislature on policy matters concerning the development and administration of Wisconsin's workers' compensation law. Having been involved in that process on a day-to-day basis, I can tell you that the labor and management teams work toward the common goal of recommending changes that benefit the entire system, workers, employers, and insurers. The advisory council process involves expert study, balanced discussion, and thoughtfully negotiated changes to the system. The product of the council's negotiations is then drafted into what's called an agreed bill that's brought to the legislature. Now, in the 50-year history of the advisory council process, legislators with ideas for changes to the Workers' Compensation Act were directed by the legislative leadership to present their ideas to the advisory council rather than introduce a separate bill. Now, because the advisory council process has earned the trust and respect of legislators, both houses of the legislature have historically deferred to the advisory council. And on the extremely rare occasion that a bill was introduced which proposed a change to the Workers' Compensation Act, that bill was automatically referred to the advisory council for consideration under the agreed bill process. That history of deference to the advisory council was placed. Republican Representatives John Spiros and Dan Conneautville and Republican Senator Dewey Strobel bypassed the advisory council and introduced a bill which, if passed, would have drastically and irreparably affected workers' rights. Now, let me repeat just a couple of points to put in perspective just how destructive the Republican bill would be. As I explained a moment ago, prior to enactment of the Workers' Compensation Act, if a worker was injured at work, he had to sue his employer for damages. Since passage of the Act in 1911, the Wisconsin Workers' Compensation System has been a no-fault system in which the parties aren't required to prove or defend against claims of negligence. The fundamental concept which undergirds the entire Wisconsin Workers' Compensation Act is that employers receive complete and total immunity from being sued in exchange for paying injured workers a limited system of benefits. In other words, it doesn't matter how negligent an employer may be in causing or contributing to the employee's injury, that employer cannot be sued by the employee. But in exchange for that immunity, an employer is required to purchase a workers' compensation insurance policy which will pay benefits for every injury that occurs during the course of employment, even if it may be the employee's own fault. But the benefits are significantly less than would be payable in the civil justice system. For example, workers' compensation benefits don't include claims for pain and suffering. They don't include claims for loss of consortium. They don't include actual loss of earning capacity, among other things. This Spiros Conneautville Republican bill threatens to repeal portions of the no-fault system, but only at the expense of the injured workers. Now, you may have heard the saying that you're 10% negligent just for being there in automobile accident cases. Now, the Spiros Conneautville bill introduces the concept of contributory negligence, which is a civil litigation concept, into the workers' compensation system, but it will only factor in the employee's contributory negligence. Under the proposed bill, if your injury is caused by any negligence on your part, your already very limited benefits will be reduced in proportion to the amount of negligence attributable to you. Now, in the civil justice system, the decision of whose negligence contributed to an accident is made by a 12-person jury after a trial and after tons of evidence. Under the Spiros Conneautville bill, the employer and workers' compensation insurer can unilaterally decide if an injured worker was negligent and then reduce the worker's benefits by the percentage of negligence they decide. Now, if the issue is truly about attributing fault for causing an injury, there would need to be a corollary provision which increased compensation where the injury was caused by the employer's failure to follow a safety rule. That would just be fair. There is no such provision in this bill. And that is among the things that is incredibly galling. While the injured worker's benefits can be reduced by contributory negligence, the Spiros Conneautville bill doesn't provide the same consideration to the injured worker by allowing an increased benefit when the employer's negligence caused the injuries. Doing away with our no-fault system would be devastating to workers and will create a system of increased litigation, since workers will now have to fight to prove that they weren't at fault at all for causing their injuries. Now, Wisconsin currently has one of the lowest litigation rates in the country. Wisconsin could now go from a 10 to 20% litigation rate to something like Illinois, where there is a 65 to 80% litigation rate. Now, increased litigation percentages and increased litigation times mean delays in payments to both injured workers and their medical providers. The delay in Illinois, for example, is between 2 and 4.5 years. Medical providers are not going to wait 2 to 4.5 years to get paid. Now, as you all probably know, unpaid medical expenses represent the single largest factor in driving people into bankruptcy. That could now be you or a family member. Wisconsin's no-fault workers' compensation law was the first in the country to have been found constitutional as providing an adequate remedy for injured workers and employers as well. By way of contrast, Florida's law has become so terrible that a judge recently declared it unconstitutional as not providing an adequate remedy to injured workers. And let me say this, it is dumbfounding to me that Florida's own Marco Rubio is polling so well in Wisconsin in his presidential bid. So if negligence is introduced into the system, but workers are barred from obtaining traditional civil litigation remedies such as pain and suffering, loss of consortium, actual loss of earning capacity benefits, and the like, then there will come a point when Wisconsin's previously envied law could be declared unconstitutional as well. Now, the Spiros Conneautville is also attempting to reduce Wisconsin's 6-year workers' compensation statute of limitations to just 2 years. The 6-year statute of limitations is there for a reason. Work-related injuries cause accelerated degeneration of a body part and often necessitate additional medical procedures years after the injury. It's pretty standard procedure for any of you who have undergone like a meniscal tear, an ACL tear in your knee. You guys are knee replacements waiting to happen. It's just a matter of time, particularly if you keep doing what you do on the plant floor. And in fact, I was just talking to a surgeon Friday, who is in the business of doing shoulder replacements. And he said, part of when they do a shoulder replacement is replacing both the ball and the socket. That socket has a life expectancy of about 8 years. They see in following up these patients at 8 years, it starts becoming loose and it's on its road to failure. Well, those guys are out of luck. A 2-year statute of limitations for traumatic injuries would eliminate any payments to employees, any payments to medical providers in situations where additional care is required years after the injury, and shift those costs to the public when it should be the responsibility of the employer or the workers' compensation insurer. This is clearly a work-related injury they get to walk away from. Now, worse yet, if there is no health insurance, an injured worker may be forced to forego necessary medical cases or medical care in cases where the injury was clearly related to the employment. Here is another provision of the bill. This Spiros Conneautville will allow an employer to select the physician who treats the injured worker. Now, it has been a staple of Wisconsin law that an injured worker has the right to be treated for their injury by any medical doctor, chiropractor, podiatrist, or psychologist licensed to practice in the state of Wisconsin. In fact, the current law also provides an injured worker the right to seek a medical opinion. Now, Wisconsin has the fastest return to work times in the country by is already in the lowest quarter of all states in the country in cost per claim without having employer-directed care. I guarantee you that directed care by employers and insurance carriers will mean a race to the bottom. Inevitably, some clinics and healthcare providers are going to make decisions which have the effect of pleasing employers with an eye toward attracting more workers' compensation business and not provide the necessary care to Wisconsin workers. The focus will not be, as it has historically been in Wisconsin, on the quality of care provided to an injured employee, but rather on competitiveness in terms of making medical care decisions that generate more business from employers and insurers, either by denying claims or ending treatment prematurely. In some clinics, like Marshfield Clinic, which is where Spiros is from, are already all about marketing to employers how fast they can get that injured employee back to work, whether he or she's ready or not. Has anyone here ever undergone an independent medical exam at the request of a workers' comp insurer or employer? Yeah. Do you want that doctor to be responsible for your care? You know, I can't imagine how that system would be abused. Now, this is the last provision that I'm going to talk about. The Spiros Conneautville will allow employers and insurers to reopen claims in which a permanent partial disability assessment was made. Now, under current law, a finding of permanent partial disability is final. But under this Spiros Conneautville, the Workers' Compensation Division is required to order the injured worker to submit to a re-examination once every 3 years or upon the request of the employer or insurer. Now, if a subsequent examiner finds a lower percentage of permanent partial disability, the workers' compensation insurer or employer can claim that it overpaid benefits in the past and demand reimbursement from the disabled worker. If the employee can't pay the amount requested, that could result in a cost judgment against the disabled worker. This provision is outrageous and would severely punish the already struggling working people who are trying to manage with the effects of their permanent disability. And you know, interestingly, as we discussed just a second ago, the Spiros Conneautville reduces the statute of limitations for employees to make further claims to 2 years.
Okay.
But in this provision, workers' compensation insurers and employers are given a longer 3-year period to contest permanent partial disability work. You know, not only would this work an injustice on a disabled worker, but it could result in an absolute explosion of litigation if the worker is forced to litigate that issue of permanent partial disability on multiple occasions over how many years? It is just this sort of maverick, unbalanced, partisan politics that the advisory council was designed to prevent. You know, one of the most important and enduring principles of the council is maintaining the overall stability of the workers' compensation system without regard to partisan changes in the legislative or executive branches of government. You know, without the efforts of the council, Wisconsin's workers' compensation system would be subject to the whim of partisan politics and would yo-yo with each election. As the political pendulum swings from one party to the other, instability is introduced into the system. That instability creates uncertainty and risk. That uncertainty and risk drives employers' workers' compensation premiums higher, and those costs are in turn passed on to consumers in the form of higher prices and impacts job creation and expansion. The efforts of the council provide stability for the entire system and a vehicle to make reasoned changes to continually improve our workers' compensation system. Now, despite the obvious benefits provided by the advisory council toward maintaining the integrity of Wisconsin's workers' compensation system, Republican legislators like John Spiros, Dan Conneautville, Dewey Strobel, and Stephen Nass have made clear that they want to blow up the advisory council process because it gives too great a voice to labor. Now, the threat to the workers' compensation system presented by the Spiros Conneautville bill was obviously the bad news I warned you about. This is the good news. As a result of tireless efforts by the AFL-CIO and lobbying by the Wisconsin Association for Justice, the advisory council process survived this legislative session, and the agreed bill crafted by the council has passed both houses of legislature and should be signed today. In contrast, the Spiros Conneautville bill will not reach the governor's desk during this legislative session. You know, while we survived to fight another day, given the current composition of the legislative and executive branches in this state, we are clearly on life support. If you, a friend or family member, have ever been injured at work, you must speak up. Who you vote for matters. I am a devout Christian. In fact, I lead a ministry at the Milwaukee County House of Correction on Friday nights. I am also an avid outdoorsman. I understand how the governor and Republican legislature swept into office in 2010 by exploiting the issues surrounding God, guns, and gays. But voting on those three issues has resulted in Act 10, right to work, repeal of prevailing wage, and now the threatened destruction of the Workers' Compensation Act, which has been viewed as a model across the nation as a good and fair system. The only way to voice opposition is to contact your legislator. That is what democracy is all about. Thank you very much.